Hello, I'm Simon Jackson from LearnLoads.com. One of the essentials of contract law is that there must be an intention to be legally bound for there to be an enforceable contract. What exactly does this mean, though? This LearnLoad video gives you a nice simple summary. Think about it this way. In my simple example, supposing either the mother or the son failed to keep their side of the bargain, it would be astonishing if either intended for 1 second that this agreement was something that they expected to go to court to enforce. One of the foundations of contract law is that the courts should seek to carry out what was intended by the two sides when they made an agreement. So if one or both sides obviously did not intend that what was agreed might actually end up in court, why should a court interfere with that at a later stage? The courts work with two simple presumptions. Firstly, a presumption about what judges sometimes describe as agreements of a social or domestic nature. This includes informal agreements between husband and wife, parent and child, or maybe even between friends. In these social and domestic agreements, the law presumes that there's no intention to create a legally binding agreement. The second presumption relates to commercial agreements. In this situation, the law usually assumes that there's an intention between the two parties to create something that is legally binding. In other words, an enforceable contract. Simple enough, right? Well, yes and no. Let's look at some of the case law where the courts have found a good reason to rebut one or other of these presumptions. Rebut, in lawyer speak, means recognize that the facts of the case have made a judge say, there's a good reason not to apply the usual presumption here. Can I tell you more? Yes, I can. Let's look at each of these presumptions in turn and talk about some of the interesting precedents. So first then, social or domestic agreements. The presumption that a domestic agreement between husband and wife cannot be legally enforced is fairly well established. A leading authority for this is Balfour and Balfour back in 1919, which involved an oral agreement about payment of an allowance between a husband and a wife. At the time of the agreement, the couple were living together. It's debatable whether Balfour and Balfour would be decided in the same way today. It was certainly distinguished in Merit and Merit in 1970, where the husband and wife were separated, no longer together, and the agreement in question was made in writing instead of orally. In this case, the fact that the agreement was between husband and wife did not prevent it from being legally enforceable. The normal presumption also applies to parent and child agreements. The law starts from an assumption that agreements made between a mother and daughter, for instance, are not intended to be legally binding. Of course, there will be no contract if one of the other essentials of a contract is absent. Assuming that what has been agreed is sufficiently certain, there are 4 things to look at to see if a contract has been formed. Just to remind you, that's offer and acceptance, consideration, capacity, and intention to be legally bound. Can this presumption about family members not intending to create a legal contract extend to friends? The answer is yes, if the court feels that the two parties concerned did not intend to create a binding agreement, they will not enforce it. Secondly, let's talk about commercial agreements then. With commercial agreements, when at least one party is a business, the presumption is reversed. In other words, the court starts with the assumption that there is an intention to create legal relations. A very good reason for this presumption is the need to protect consumers. After all, it would be unfair if a business, having sold goods to a private individual, was able to avoid its obligations under an agreement by somehow showing that it wasn't really a legal contract. So, to rebut this presumption, courts would generally need strong evidence in relation to commercial agreements. But as with social and domestic agreements, the presumption may sometimes be successfully rebutted. Let's look at 2 examples to explore this. And the first one is what's called honourable pledges. You might want to look at a case called Rose and Frank and Compton Brothers back in 1923. The claimant and the defendant businesses had bought and sold from each other for some years. In 1913, They drew up a written agreement. However, the agreement included these words: "This agreement is not entered into as a formal or legal agreement, and shall not be subject to legal jurisdiction in the law courts, but it is only a definite expression and record of the purpose and intention of the parties concerned, to which they each honourably pledge themselves." When the claimant brought an action for breach of contract against the defendant, Lord Scruton, on appeal, said that there was no reason why parties should not simply rely on good faith and honour, rather than settling disputes in the courts. A legally enforceable contract had not been created because of those words. A second example is the use of the word subject to contract in an agreement. If an agreement includes a phrase such as "this agreement is made subject to contract," the courts will normally accept that there is no intention to be legally bound until a further document has been drawn up and agreed. However, be aware that if the parties include the phrase "subject to contract" and subsequently carry out the terms of their initial agreement, then the courts might interpret this as evidence that a final contract has in fact been decided. Just a word about collective bargaining agreements. What is a collective bargaining agreement? Well, it's a document drawn up after negotiations between an employer and a trade union on employment terms and conditions. In the UK, the Trade Unions and Labour Relations Act 1992 creates a legal presumption that collective bargaining agreements are not intended to be legally binding. So, to be legally binding, these agreements must explicitly state that they're intended to be so. Another way to make collective bargaining agreements legally binding is to actually incorporate them into individual contracts. So, to sum up, the general presumption with social and domestic agreements that there's no intention to be legally bound. With commercial agreements, the general presumption is that agreements are intended to be legally binding. Both presumptions are capable of rebuttal. In other words, the presumption may be successfully challenged in certain sorts of factual situations. Hope this has helped. If you like this video, click on the like button or put a comment below. Feedback helps me decide what videos to make and how to improve on what I'm doing. To see videos about offer and acceptance or consideration, click on these links. And if you're interested in more Learn Loads videos about the law, you can subscribe to the Learn Loads channel. There's lots of popular videos for business students there as well. And you can also go to learnloads.com. Thanks a lot. Bye.